What up, what up, what up, what up, what up? How y'all doing? How y'all doing? It's your boy, Atmos Love Zone Live. We back, y'all. We back. So I wanted to go ahead and just do the video. Just record it, and then we'll probably do lives probably on StreamYard until I get this thing totally corrected. But there were some things I wanted to go over this morning that I didn't quite get to go over. I kind of did when we went on Miss April Shower's channel, so I was able to address some things. However, there's a lot of information in this motion that I think that we need to pay attention to, because what they are trying to do, in my personal opinion, is they are trying to, as Miss Lady Alicia said, throw a whole bunch of stuff at the wall and hope that something sticks. Now, they are coming at this judge on all different types of angles. His medical issues, his due process rights being violated, him not being able to have proper time with his counsel in order to be able to prepare for his trial in 39 days. So what you got to think about is that all it takes is one of those things that could actually really get him a bond, get him out of there, and also give him the opportunity, if they were trying to do some type of master plan for him to try to flee the country, I think this will probably be the best time for them to try to do something like that. But I think with the allegations and with the charges that are against him, I think it's going to be personally impossible for her to release him, simply because really all he's trying to do is get back to Joycelyn, trying to get back to controlling the way he had things running before he got locked up. And I think that it's too much of a risk for them to just say, hey, okay, go ahead and go. And I don't think that the courts have enough, confidence in the system to keep him, let's say, under control. I mean, this man has been running wild and out of control for a very long time. A very long time. Even after he beat the case in 2008, he still went back to doing the same exact thing. And I think you all know what the definition of insanity is. It's doing the same thing over and over and over and over and over and expecting a different result, right? So the only way that you can prevent insanity is by changing the way things are run. So here's a couple of things that definitely stood out to me that I wanted to go over with you all, okay? Let's see here. Pull this up. Hopefully y'all are doing great, having a great day. My day is going super. So it says here, this here is the motion that they just released yesterday. This is page 4. It says, the right to access counsel and assist in Mr. Kelly's defense. It says this court has the authority to grant Mr. Kelly temporary relief pursuant to 18 USC and 3142. The language of 18 USC that the court may permit the detainee's temporary release to the extent that the judicial officer determines such relief to be necessary. Okay? That word necessary is a key word in that paragraph. It says underscores the discretionary nature of relief under the subsection. The statute goes on to say the judicial officer may, by subsequent order, permit the temporary release of a person in the custody of the United States Marshal or another appropriate person. Or another appropriate person. To the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. United States versus Chandler. So they do cite case law here to try to back up their point, to pretty much say, hey, this has been done before. This has been done before. So it's nothing for you to do it, Judge. Just look, it's been done before right here. So, I mean, all you're doing is doing something somebody else did. It says further, the court held the right to consult with legal counsel about being released on bond, entering a plea, negotiating and accepting a plea agreement, going to trial, testifying at trial, locating trial witnesses, and other decisions confronting the detained suspect, whose innocence is presumed, is a right inextricably linked to the legitimacy of our judicial justice system. United States versus Chandler. United States, they cite another one. United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. So, I want y'all to pay attention to that really quick. It says here, in our society, liberty is the norm. What do you attach to liberty? Freedom. Freedom is the norm. And detention, being locked up, being restricted, being held away, prior to trial or without trial, is the carefully limited exception. So what they're saying is, it is an exception. Like, why are you doing this to him? It's normal for people to be free before they actually have to go to trial. Why are you making him the exception? Why are you singling him out when it is the norm in the justice system that people are free until they are either proven guilty or they go to trial? It says these seemingly simple thoughts, that an individual is presumed innocent, that an individual should not be incarcerated until he has his day in court, and that no matter how damning the allegations against a defendant appears, pay attention to that. It says, and that no matter how damning the allegations against the defendant appear. So, are you admitting that there are some damning allegations against your client? It says here that he is entitled to a fair fight with adequate preparation. Should be considered by this court in determining the release of Mr. Kelly from prison prior to his scheduled jury trial date. So, what we have to understand, y'all, is that they are trying to use other cases in which the defendant has been released before his trial date or prior to going to court, in which they had the opportunity to sit down and be with counsel and actually prepare better for trial than they say Mr. Kelly is having the opportunity to do. Now, if this man was not in court, now I do want to know what the charges of Chandler and Salerno were. I think I'm going to actually look that up. Let me see. Because I'm definitely interested to know if they're trying to use that. Okay, let's see here. So that is United States versus Chandler. Let's see. Court opinions. United States versus Chandler. Okay. Let's see, y'all. Let's see, y'all. Okay. It says here. Disclaimer. Only found. Chandler. Official Supreme Court law. Co-owners should not be compelled applicable treasury for making enter transfers such bonds having reissued case. Okay, bonds federal case presents a narrow federal estate tax issue. Does the registered co-owner United States Savings Bond Series E by physical the United States District of Columbia ruled that the co-owner had accomplished his this disventure and rendered judgment in favor of the taxpayer estate. The United States Court of Appeals for the Ninth Circuit affirmed for the reasons set out in the court's opinion. Y'all, this Chandler, this is 1973. This is United States Chandler. That's 2020. This might be a different case. I'm gonna research that, y'all, because now I am interested to see why they are using these other case laws as if they are, unless they have the same exact charges as R. Kelly. I can't see what the relevance of that will be. Let me move on a little teeny bit. Let's see here. It says failure to release Mr. Kelly will inevitably lead to a reduction of his constitutionally mandated right to assess counsel and to assist in his defense during what the Supreme Court has found to be the most critical period of a case proceeding, the time between arraignment and beginning of the trial. They cite more case law, Powell versus State of Alabama. It says the Bail Reform Act, including a provision that would allow a judicial officer to permit the temporary release of a detainee if judicial officer determines the release to be necessary for preparation of a person's defense for another compelling reason. And then they're citing more case law. Boom, 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 boom. So, to make a long story short, y'all, every single thing that they are trying to compel this judge to act on their favor with, they have case law to back it up. I think that when you're looking at stuff like this, you have to actually look in to see exactly what the charges of the people whose case law they're using, see what kind of charges they had to see if it even matches up with the types of charges that R. Kelly has, to see if it even evens out. Now, we already know that they used Avenatti a couple of times. They said his name all through this motion. And I assume that, like I was saying earlier, that was in a way to say, hey, well, y'all let this guy out. Although he was already convicted, my client hasn't been convicted yet. He's just charged with something from a bunch of allegations. So why don't you let him out to prepare for his trial? So it's something that I want y'all to definitely keep your eyes open on and really pay attention to. It's a lot of stuff in these motions that I really never paid a lot of attention to, but when you really read them, they kind of tell you what the psyche of and the strategy of the defense and the federal government is in trying to either win or rebut. So the government has the opportunity to rebut this motion. They have until, I believe, July 6th to do that. I believe today they put out Judge Donnelly put out that they had until July 6th to respond to this motion. So we'll see what happens. But listen, I love y'all. Thank y'all very much for watching this video. Please like, share, and subscribe. And also, if you have any questions for me, make sure you put them in the comment section. And if you have anything else you want to say, leave it in the comment section, okay? Shout out Larry, Free Larry. Y'all be a blessing to him if you can. $Cuphead40. Y'all have a blessed night. I will holler at y'all later.